Welcome to Quick Revision. Today, a quick revision capsule on Section 13 of the Transfer of Property Act 1882, Transfer for the Benefit of an Unborn Person. As a general rule, the Transfer of Property Act permits transfers only between living persons. This principle comes from Section 5, which requires the transferee to be in existence at the time of transfer. However, Section 13 creates an important exception. It permits a transfer for the benefit of an unborn person, even though that person is not in existence on the date of transfer. First, let us understand who an unborn person is. An unborn person is a person who is not yet born or not in existence at the time of transfer. Now, remember an important rule. A transfer cannot be made directly to an unborn person. The transfer must first create a prior interest in favor of a living person. This prior interest is generally called life interest. Only after creating such a prior interest, the property can be transferred for the benefit of the unborn person. Another important condition is that the unborn person must receive the entire remaining interest of the transferor. In other words, the unborn person must receive an absolute interest and not merely a limited interest. The unborn person acquires a vested interest upon birth, although actual enjoyment may be postponed until the termination of the prior life interest. Now, let us remember the essential conditions for a valid transfer to an unborn person. The transfer cannot be made directly to the unborn person. A prior interest must be created in favor of a living person. Any number of life interests may be created in favor of living persons. The unborn person must receive the whole remaining interest of the transferor. The unborn person must come into existence before the death of the last life estate holder. The interest cannot be postponed beyond the limits permitted by law. You may also come across the term rule against double possibility. This means that while life interest may be created for living persons, a life interest cannot be created in favor of an unborn person and then again in favor of that unborn person's unborn children. The law does not permit such remote transfers. Remember, Section 13 should always be read along with Section 14, which deals with the rule against perpetuity. Quick exam recap. An unborn person is a person not yet in existence. Section 13 is an exception to the general rule that transfers must be between living persons. Property cannot be transferred directly to an unborn person. A prior life interest must first be created in favor of a living person. The unborn person must receive the whole remaining interest. The unborn person must come into existence before the last life estate ends. Section 13 and 14 are closely connected and should be studied together. That's your quick revision for today. Keep listening, keep revising, and write your exams with confidence. See you soon in the next QLR capsule.